Hey, it's Judy Bratt, CEO of Summit Insight, and we're just about 4 minutes from the start of our fiscal year-end webinar on a topic I know you're going to appreciate on debriefings. We're going to get the share ready, and our participants and co-hosts are logging in now. We're getting everything lined up just for you, and we are so glad that you're with us. We hope your federal fiscal year end is rocking it and that you're getting lots of questions lined up for us, because we've got a super presentation all lined up for you, and we'll be getting started in just a few minutes. So if you've got questions or greeting you want to drop into the chat, please do that. And we're going to get started in just 3 minutes at the top of the hour. I can see folks logging in from all across the country. Welcome. We are so glad that you are here. Come on in. Maria, are you with us?
I am. Hello.
Hi there. How are you doing?
Good. How are you?
Okay. So what do you think? This year you're gonna see more protests, fewer protests, or about the same as last year? It's a question out of the blue, I know. Any guess?
I'm guessing this whole year has been odd in terms of timing, but it seems like there's been less protests during the year, and every one of my clients who I've talked to about it has said that the government's moved very slowly on dropping awards this year. So I'm expecting that there's going to be a sudden rush, and with a sudden rush of dropping awards comes a sudden rush of protests. So I'm bracing for a rush any day now.
Got it. All right. So I've got Heather on as co-host, and we are just about ready. We're 2 minutes to the top of the hour, and we will get started. So we are so excited that you are here. Deanna, Junann, Kirsty, welcome. We're just so excited to be here. If you are logging on and you see your name coming up as somebody who's not you, please change your name so we know who you are. If you've got questions, again, we'll be covering this in a minute, but if there's anything you want to make absolutely sure we cover, please drop it in the chat, and we'll do our best to get all of those to you. So we are just 1 minute from the start, and we'll get this rolling for you. So welcome. We're really excited that you are here. We've got people. Hello, Noli. So glad you're here. People logging in from across the country. And I know there are others who are going, I'm just trying to get my bids in for fiscal year end. We've got you. That's why we've got the recording. So if you're listening to this on the recording, welcome. We're so glad you were able to join us and to register. And I hope you'll share this with friends and people you care about. So we'll be getting started in just a second. Less than 1 minute to count down. We're also close to counting down to the start of a new fiscal year. It's exciting. So we're almost ready to rock. Again, welcome to our webinar, Debriefings, a key tool in bid protest analysis and business development. All right. And we are rocking and rolling. Let's get this show started. Hi, welcome. My name is Judy Bratt. I'm CEO of Summit Insight, and I'm here to bring you the best of what you need from over 30 years in the federal arena and over $200 million in client wins. I want to help you focus, connect, and win, about which more really soon. In the meantime, as we get started, Summit Insight is a professional services company. We focus on helping companies that want to build more success in the federal arena. And a special welcome to you who I'm meeting for the first time. I'm so glad you're here. If this is your first webinar with us, please drop a number 1 in the chat so I can know who you are. For you, and I hope for us as well, sales and marketing are acts of service, which is why we bring you this webinar series. You can find out if you're a fit to work with us and get lots of free links to resources along with my book and workbook in our follow-up emails. And you're going to get a copy of this recording, slides, and the bonus links by Friday afternoon is our goal for this week. So all that said, here's what we're going to cover today. When and why to request a debriefing, when a debriefing is and isn't required, and why that matters. What's the difference between a debriefing and a brief explanation and why that matters? What you will and won't get in a pre-award and post-award debriefing. Who should attend a debriefing? How to prepare questions, when to engage an attorney, and how debriefings can impact bid protest filing deadlines. Ways to participate. Drop your questions in the chat box, raise a hand. At the end, you'll have the chance to unmute for live Q&A, and you can book a follow-up call. Link at the end. Watch for next day follow-up, including bonus links and a recording. Get out your notebook. I'm going to ask you at the end what action you're ready to take because you were here. So be ready to share. My aha is, and I commit to do what and by when. Help us help you. My co-host and moderator today is Heather Herbine. She's co-founder of Transcendence Marketing, and they combine best practices and tested methodologies to make you give you a one-stop shop for your federal sales, marketing, and connection services for all things digital, from social, from cold calling to CRM setup and management. The company's founders each have over 15 years experience opening doors in the federal arena. They support my team, and I hope that you'll connect with Heather to help connect with yours. So Heather, tell us about our poll.
Hi, at midway through the webinar, we'll be launching a poll to kind of just get a little information about who you are and what you do and how we can better serve you in the future. So thanks so much for joining us today.
All right. So drop your questions in the chat or message to Heather Herbine. We'll get them at the end of the presentation. And if we're unable to answer your question before the webinar wraps, we'll forward to our guest, Maria Panichelli, so that she can get to you directly and answer your question to help you out. And so with that, it is my joy to introduce Maria Panichelli to you. Maria and I have been friends for many years, and she is the partner and chair of the government contracting department at the law firm of Obermeyer, Redmond, Maxwell, and Hippel, with offices in Philadelphia and Washington, D.C., guiding her clients through the full life cycle of federal contracts. Maria has represented her clients across the full range of federal agencies and before the Government Accountability Office, Contract Board of Appeals, the Court of Federal Claims, and the United States Court of Appeals for the Federal Circuit, and other state and federal courts. Her practice covers teaming, joint venturing, mentor-protege, prime sub dispute resolution, status and size eligibility, and certification issues. Her clients are large and small across a wide range of industries and could be anywhere from coast to coast. She's a frequent lecturer and author on procurement and federal small business related topics, and she's thrilled to be partnering with Summit Insight again to deliver quality educational content to federal contractors. So Maria, welcome back.
Thanks, Judy. Thank you for having me. I am thrilled to be with you guys and happy to be talking about debriefings today. So next slide, please. We're going to start with talking about just generally speaking, what you should be thinking about with debriefings and how you can use them. But the first thing I want to kind of start off with is the idea that a lot of you out there are probably looking at debriefings as a first step towards protest. And that's absolutely true, but that's not the only time you should be thinking about a debrief. Next slide, please. This is a tool that you can use not only to gain information when you're thinking about potentially protesting, but it's a tool that you can use even when you won the award to try to figure out how you as a company and you as proposal writers can perform better and do better going forward. So, I guarantee you, no matter what, your proposal wasn't perfect. Your quote, your bid, your proposal, depending on, what you're responding to, wasn't perfect. There's room to improve. Even if you won, get a debrief and see what they liked and what they didn't like. In addition, it's a relationship building tool. If you get a debrief, even when you won, I think the agency is going to respect that you're trying to improve, that you're diligent about taking constructive criticism and trying to incorporate that. you're going to gain some insight into the agency's mind, especially if you do business with the same agency over and over again. It's going to establish more of a rapport because you're, opening up an opportunity to have a conversation or to learn a little bit about their review process. And they're going to know that it's not a situation where you're being combative. So they're going to come to it a little bit more. Overall, you'll never know what you may learn until you ask for a debrief, even when you win. I want to now talk about a little bit, give you a small primer on the procurement process. Next slide, please. And as part of that, you need to be thinking when you're using debriefs in a protest context. Can we move to the next slide, please? There are some critical questions and considerations that you need to be focused on. And Judy, I'm not sure if there's an issue, but I'm not seeing the slide move forward. We're looking for the slide that says a primer of foundational understandings of, there we go. So there's three major questions you need to be asking yourself. What method of procurement is being used? What type of contract is at issue? And who are you dealing with? And the reason that these things become important is that they change what is and is not available in terms of getting a debrief, changes the timing of when you need to request a debrief, changes the ensuing timing of what a debrief does or does not do to your deadline to file a protest. So just to give you a little bit of background, what I mean by what method is being procured, I mean what part of the FAR is this procurement being run under? Is it a sealed bid under FAR Part 14 where the lowest responsive and responsible bidder is going to win? Is it a competitive procurement under FAR Part 15 contracting by negotiation where you've got price and non-price factors and there's going to be some sort of best value or trade-off situation? Or are you talking about a GSA contract or a simplified acquisition or something that's for commercial items? These are all going to have an impact on what part of the FAR you're dealing with and therefore what laws control and therefore, how debriefings and ultimately if you go the protest route, how they fit into the framework and what you need to do and what your rights and obligations are. When I say competitive range, for those of you who don't know what that is, competitive range is when the government in a FAR Part 15 negotiation decides that they're going to take, kind of the best performing people, the best performing offerers, and put them in a competitive range, let everyone else know, hey, I'm sorry, there was 25 people that submitted responses to the solicitation. We took the best 15, the other 10, thanks for playing, but you are not going to make it into the competitive range. The government then conducts negotiations with the people, or discussions rather, with the people who are in the competitive range. They have the ability to revise their proposals and then go forward and an award is made on those revised proposals. LPTA is lowest price technically acceptable. That's another concept that is sometimes used. Basically, the government has a number of non-price factors, and you have to be deemed, a certain level of technically competent or quote-unquote technically acceptable. But then once you cross that threshold, all of the bidders or the offerers who cross that threshold are going to be just considered by price, and the lowest price offer is going to get the award. Now, LPTA was kind of on the way up. It was being used more and more frequently. For obvious reasons, contractors did not love it. There was some pushback, and recently there's been, recently, about a year or so ago, there's been some limits put on when the government is and is not supposed to use LPTA. So those are all things to think about when I say what method of procurement is being used. Contract type, is this an IDIQ? Is it a GWAC, a government-wide acquisition contract? Is it a set-aside contract? Is it a task order under a GWAC or an IDIQ? These things are also going to impact your ability to get a debrief, your debrief rights, and then how the debrief does or does not affect a protest deadline. And then finally, who are you dealing with? Are you dealing with multiple agencies, just one agency? Is the GSA procuring something on behalf of another company? Is it a GSA GWAC and the Air Force is issuing a task order underneath of it? These things come into play oftentimes when you're talking about jurisdiction for your ultimate protest. And also the debriefing rules. There are delineations between defense agencies and civilian agencies. So next slide, please.
May take a second. Can you see it?
Not yet, but I'll start. What I want to, and might as well go forward too. what I want to talk about is what you actually get and don't get in a debriefing. And there's a distinction made between post-award and pre-award debriefings. And I think we're still on the questions, Judy, just so you know. What's in the debriefing for a pre-award debriefing? And that is when you are excluded from the competitive range. That's what I mean by a pre-award debriefing. You are going to get a pretty limited set of information. You're going to get the agency's evaluation of significant elements in the offeror's proposal. You're going to get a summary of the rationale for eliminating the offeror from competition. And most importantly, you're going to get reasonable responses to relevant questions about whether source selection procedures contained in the solicitation, applicable regulations, and other applicable laws and authorities were followed. All right, I think we're about 3 slides behind. We should be on slide 9, where it says what's in a debriefing, pre-award debriefings.
That's the one I'm showing on my screen. So with any luck, the broadcast will catch up. Heather, what are you seeing?
I'm seeing a premier foundational understanding, critical questions and considerations. So it's not, I'd maybe refresh, Judy.
Okay. Hang on a sec. Oh, I'm going to stop share and restart. Let's see if that can reboot it. There we go. How's that?
I'm not seeing anything.
Okay. It may take a second. Looks like for whatever reason, we've got a bit of a lag. So I'm on the slide, what's in a debriefing and what they shall not disclose. So that's what's coming up as soon as the system gets ready to show it to you.
All right. Well, while we're waiting, I'll kind of just go over it for the attendees. What you're not going to get in a pre-award debriefing is the number of offerors, the identity of the other offerors, the contents of those offerors' proposals, the ranking of other offerors, or the evaluation of other offerors. You're also not going to get, and this one's pretty common sense, any trade secrets, privileged or confidential manufacturing processes, techniques, basically any proprietary or confidential information. The way the government looks at this is, a debriefing is not a tool for you to start gathering information about how your competitors do business. Obviously, otherwise people would just be getting debriefings left and right every time they were able to in order to gain a competitive advantage, over their competitors. All right, so we've got the slide up, but now it's time to move on to the next slide, which is what's in the debriefing post-award debriefings. You're going to notice that you get a little bit more in post-award debriefings than you do in pre-award debriefings. At a minimum, post-award debriefings should include the government's evaluation of significant weaknesses or deficiencies in the offeror's proposal, to the extent that they're applicable. You're also going to get the overall evaluated cost and price, and that will include unit prices, of both you, the party that's seeking the debriefing, and the successful offeror. You're also going to get the overall evaluated technical rating for you, the potential protester or the debrief party, and the actual winner. And then you're going to get the past performance information about you. You're not necessarily going to get the past performance information, or I should say you're not going to get the past performance information about the winner or the winners, the awardees. You will get, if one was created, an overall ranking of all offers. Trend-wise, the government does this less and less for the very reason that providing a ranking gives you possibly wiggle room to make some more arguments. You're going to get a summary of the rationale for award. That can be everything from a detailed explanation as to why you were the best, why you weren't the best and why the awardee or awardees were the best choice. Or I've seen very, very cursory paragraphs which just simply say, the awardee presented the best value. So it's really depending on, the magnitude of the contract, the importance of the contract, the strength and skills of the contracting source selection team, and kind of the agency you're dealing with. If it's commercial item acquisition, you're going to get the make and model of the item to be delivered. And finally, you'll see that this matches up with what we talked about with pre-award debriefing. You are entitled to reasonable responses to relevant questions about whether source selection procedures contained in the solicitations, applicable regulations, and other authorities were followed. So what the takeaway should be is for both pre-award and post-award, you have an opportunity to ask questions about whether the solicitation evaluation framework was followed, about whether applicable law was followed, and it really pays to prepare in advance and come up with those questions because you have a right to ask those things. Next slide, please. In terms of what you're not going to get in a post-award debriefing, you're not going to get, and the language is pretty specific, you're not going to get a, what they say, point-by-point comparison of the debriefed offer, you, versus the other offers. So they're not going to go point by point and say, let me compare everything that you did to the awardees. But you're going to get, the things that we just talked about on the previous slide. You're also not going to get, again, trade secrets or confidential or privileged information, commercial and financial information that is privileged, confidential, including cost breakdowns, profit, and you're not going to get the names of the individuals or specifics about the offerers, the winning offerers' past performance. Next slide, please. And we can move forward to the one that says, what are you listening for? So we talked about upfront at the beginning, the fact that you should try to use a debriefing no matter what to go forward, even if you won, as an information gathering tool, etc. But what you guys are probably mostly thinking of is debriefings as a precursor to protest. So let's talk about, what you would be listening for if you are in that scenario. And we should be on the slide that says, what are you listening for? What is protestable? Depends on the nature of the procurement. So remember I asked about those fundamental questions that you have to be thinking about. What is the nature of the procurement? Is this a FAR Part 15 procurement where there were price and non-price evaluation factors such that, the agency might have messed up their price evaluation or their evaluation of something like past performance? Or is this something where basically everything came down to price and you've got to come up with a pricing argument? In that case, we're still on the slide previous. In that case, you need to be careful about the questions that you prepare. What you really want to be focused on are, did the agency follow the solicitation stated evaluation scheme? Did the agency follow or comply with applicable law? Are you looking at price or non-price factors or both? And were there procedural defects in what the agency did? So in terms of, more specific issues, and now this is the right slide, common non-price evaluation factor issues involve things like unstated evaluation criteria or sub-factors. So for example, the agency said, we're going to give a lot of credit for people who have done jobs like this before for the federal government. But then when they actually are evaluating things, they give specific preference to people who have done it for their agency. Well, that's more specific than just federal government experience. It's, experience with that particular agency. And there's an argument to be made that, hey, if I had known that, I would have put in, I would have used the limited space I have in my proposal to highlight what I did for this agency, but you didn't tell me that that was more important, so I put my most impressive projects in, across the whole federal government. A lot of these arguments come back to, did the offerers have fair notice, and would they have been able to kind of do different things in their proposal to give them a better competitive edge if they had been given proper notice. So the idea is you used an unstated evaluation criteria. That wasn't fair, and therefore, this is a protestable issue. There's also the idea that there could be an error in applying evaluation criteria or assigning ratings. The solicitation is going to lay out the evaluation framework. Here's the factors. Here's how we're going to judge them. Here's how we define those adjectival ratings. If there was a mistake in doing that, that's another basis. Unequal or disparate treatment of offerers is when, as the name would imply, offerers are not treated the same. Maybe one is given the benefit of the doubt and rounded up to the best adjectival rating every time, whereas another one is, anything that they can throw at them in terms of criticism, it's thrown. And I think at this point the slides seem to be having a mind of their own. So I apologize, guys. I'll try to make it clear what slide I'm talking about so that you can follow along when you get the slides in the recording. I'm still right now on the slide that says, what are you listening for? What is protestable? And has two columns, one with non-price and one with price. The last thing, remember that competitive range concept where I talked about opening discussions. Other issues that you could be listening for are whether there were meaningful, misleading, or uneven discussions. In other words, were you given the same amount of information in the discussions that other offerers were, or maybe were you given limited information and the awardee was told point by point what to revise in their proposal such that they had a better chance of knowing what the agency was really looking for. In terms of price, you're going to be looking for, price reasonableness, price realism arguments, anything where maybe the escalation prices were adjusted. Sometimes the government does that. Balance pricing, and of course, if you're a hub zone, there's a hub zone preference, and if they didn't apply that, that could be an issue. But basically, the idea is these are the types of things you're listening for. How do you learn whether these things happened? How do you learn whether there's something protestable that occurred? That is where you turn to your debriefing. That is where you use the questions in your debriefing to prod these issues. Remember, not all protests are created equal, so you're going to be looking for, objective arguments. Next slide, please. The next thing you have to keep in mind, especially as we're looking at debriefings as a precursor to protests, is the impact that debriefings can have, but careful about this, because the caveat is do not always have on the deadlines for your protest. There are different types of protests, and they have different deadlines, which means that different considerations and factors and thought processes apply. Sometimes those deadlines are tied to when you get your debriefings, and sometimes they are not. So you got to look at debriefings, in I guess 2 ways. 1, information gathering tool, even if you won, how do you improve? 2, as a precursor to a protest or a potential protest, as an information gathering tool about what maybe went wrong in the solicitation process. And then you need to also think about, in the context of precursor to protest, is this going to change the deadline by which I need to file my protest? Next slide, please. So again, protests are defined and are dependent on what you are protesting and where you are in the procurement timeline. So the government identifies a need, puts a solicitation out on the street, gets responses, may or may not enter into that competitive range discussion saying if it's a FAR Part 15 procurement, selects an awardee, and then notices go out, correct? So it's critically important to understand where you are in that chronology and understand that there are different jump-off times, different trigger moments, different catalysts. Next slide, please. And you need to understand where you are and where you jump off from. And again, this is just kind of a summary of that chronology, that trajectory that you go through. So next slide, please. The big thing that you need to keep in mind is that the deadline, the rule for protests, is that you've got 10 days from the day you knew or should have known the basis of your protest. So pre-award protests are different. That's when there's a problem with the solicitation itself. And I'm covering this even though it doesn't technically tie into debriefings, because you're not going to get a debriefing in a pre-award stage. What I mean by pre-award is you got the solicitation, there's something wrong with the solicitation itself. There's a term in there that shouldn't be in there, or there's a term in there that's missing that should be in there, or there are things that are directly contradictory or ambiguous and you need to ask questions. Those are the types of things, or it's set aside and it shouldn't be set aside, or it's not set aside and it should be set aside. Those are the types of issues that you bring up before you even respond to the solicitation. That's a pre-award protest based on errors in the solicitation, and they need to drop real quickly. You need to protest them before you respond, the deadline to respond to the solicitation. But otherwise, if you're talking about, a protest that would be based on the exclusion from the competitive range, or a protest based on the post-award notice of unsuccessful offeror, we're looking at 10 days from, the day that the clock starts ticking. We're going to talk about that in just a second. If you want an automatic stay, which is, okay, not only is my protest timely, but I want the extra mile at the GAO to get everything paused while we litigate this matter, so that if I win the protest, the performance is not underway, then you're looking at a 5-day deadline from when your clock starts ticking. So obviously, the key question becomes, okay, I'm talking about a potential protest. It's not a pre-award solicitation protest. It's a competitive range protest, or it's a post-award protest. How do I know? I know I've got 10 days or 5 days from, the magical day that the clock starts ticking. When does that clock start ticking? Next slide. And this is where contractors often have confusion over debriefs and how debriefs kind of interplay with the deadlines for protests. So the exception that everyone thinks is the rule is that in protests where it's a competitive procurement and you have therefore a required debriefing that is timely requested, you have to bring your protests not later than 10 days after the date that the debriefing is held. However, like I said, that's the exception, even though everyone thinks that's the rule. A lot of contractors, if you say, what's a deadline to bring a bid protest? They say, 10 days from your debriefing. Well, that is true if it's a situation where you have a required debriefing. In other words, the government is required to give you a debriefing as long as you ask, and if you timely request that required debriefing. But the general rule is 10 days from the day that you should have known, that you know or should have known the basis of your protest. So in other words, unless you fall into the exception of required debriefing, and that required debriefing was timely requested, you're not talking about a deadline that's 10 days from the date of your debriefing. You're talking about a deadline that's 10 days from, quote unquote, the day you know or should have known. Most of the time, that's going to mean the day you got the notice of award. So you can see how this can be a big mistake for a contractor to make. They get the notice of award, they ask for a debrief, the government might give them one, let's say 5 days later. But in the meantime, it wasn't a required debrief, or maybe the contractor didn't timely request it. And so they have not told their deadline. They're now 5 days into their protest process, and they didn't think so. They thought they had 10 days from the day of the debriefing. So it's really important to understand this is the exception to the rule, not the rule. So then the question becomes, well, how do I know if I'm in a situation where the exception applies? How do I know if I have a required debriefing? Next slide, please. Answer is pretty simple, because there are only limited situations where you have a required debrief. The biggest one is if you've got a competitive procurement under FAR Part 15. So anytime that you have a solicitation that's using FAR Part 15, best value, trade-off, that type of terminology. And again, you're going to want to look at the solicitation, and if you have questions about whether it's a FAR Part 15 procurement, consult a lawyer who specifically has knowledge in government contracting, and do it early, because all FAR Part 15 procurements have required debriefings. Also, under FAR 16505B6, task orders or delivery orders that are over $5.5 million shall follow debriefing procedures. But again, you're going to want to make sure that you are looking really carefully at the information in terms of what type of procurement you're dealing with. Sometimes FAR Part 8, which is GSA contracts, or sometimes different types of IDIQs or GWACs, will incorporate certain types of FAR Part 15 procedures. You need to kind of understand how those things are stacked and have a lawyer look at them to know if FAR Part 15 procedures relating to required debriefings do or do not apply. If they do, then great, you're in that exception where you've got 10 days from the date of your debriefing. Otherwise, no dice. You're not in a required debriefing situation. So debriefings are not required for GSA schedule procurements under FAR Part 8, sealed bidding acquisitions under FAR Part 14, commercial item procurements under FAR Part 12, and simplified acquisition procurements under FAR Part 13. Now, one thing I do want to note is that under FAR Part 8 and FAR Part 13, when an award is based at least partially on valuation factors that are not price, so non-price evaluation factors, a debriefing isn't required. However, the agency is required to provide something called a quote-unquote brief explanation of the basis for award. This does not constitute a debriefing, and it has no impact on your deadlines. I will tell you, many, many contracting officers and many different people at the government will tell you, here's your debrief, and then they'll give you something that's actually technically, from a legal standpoint, a brief explanation. So don't think that just because you requested a debriefing and got one, don't think that just because you got something from the government that they're calling a debrief, that you actually have a debrief that was required and that you are subject to this exception. So this can get a little bit tricky. The next question, remember, is not just whether the debriefing was required, but whether it was timely requested. There's two different times that you need to worry about timely requesting a debrief. If the agency conducted the procurement on the basis of, competitive range, if you are one of the people who did not get into the competitive range and you got a notice saying, like I said before, hey, 25 people went after this, we took the best 15, we're entering into negotiations with them, but I'm sorry, you're not one of those 15, you've been excluded from the competitive range, thank you for playing, have a nice day, do not collect, do not pass go, do not collect $200. That is when you have 3 days to request in writing a debrief in order to be timely. Now, it might be that the agency says we're deferring all of the debriefs until after award. That's okay. You've put your foot in the door. You've requested your debrief within 3 days of getting excluded from the competitive range. That's what you need to do to be timely. The other time, and this is probably the more common since, competitive range doesn't happen on every procurement, but the other time is when you get that final notice of, unsuccessful offeror. That is when you're going to want to drop your, within 3 days written request for a debrief. So remember, you've got to keep in mind in terms of, how a protest can affect, or how a debrief can affect your protest deadline. Are you looking at 10 days from the day you got the notice of award, or are you looking at 10 days from the day you get your debrief? You're only looking at 10 days from the day you get your debrief if it's a required debriefing. So FAR Part 15 is usually going to be the way that you get under that umbrella. And if you timely requested it by asking for a debrief in writing within 3 days after either getting your competitive range exclusion notice or your unsuccessful offer notice. So you can see how these things get a little bit complicated, and then obviously there's a further wrinkle that all of the 10-day deadlines, if you want to stay, actually go down to 5-day deadlines. Next slide, please. So in terms of the logistics and the mechanics about how debriefings are given, they can be given in person, they can be given telephonically, and they can be given in writing. I would say that even before COVID, it was very, very rare to get them in person. You would sometimes get them telephonically, and increasingly, and depending on what agency you're dealing with, you would get them in writing. You get a written debrief. Now, you might ask, and we're going to circle back to this a little bit later with regard to some developments, especially with DoD agencies, but you might ask, if I have a situation where I get a written debrief, how am I supposed to get in those reasonable responses to relevant questions? I have a right to ask those questions. And I'll be honest with you, that's kind of a case-by-case thing that you're going to want to talk about with your lawyer. If you're told, we'll give you a debrief on Friday, get your questions in so that maybe they can include the answers in the written response. Because unless you're dealing with a DoD agency, and again, we're going to spend a little bit more time on this in just a minute, if you get your written debrief and you ask questions afterwards, can be a little bit questionable about whether that does or does not toll the deadline. For Department of Defense agencies, it's going to. For civilian agencies, it's not going to. And we'll talk about that when we talk about the deviations. But, it's, I think, always better to try to have it telephonically if you can. More of a back and forth. You have some opportunity to kind of hear what's going on and, ask questions and have it be more of a dialogue than just, a written document dump. And I think that allows you to get more information. But you don't always have the opportunity to choose. But if you are given the opportunity to choose, I always say, I'd like, the preference would be to have an oral telephonic debrief followed up with any written materials that you have. In terms of tone, again, you want to get information out of this. So the more politely and non-combatively you can address the government, the better. Ask your questions. Make sure that you know what you're doing going in, that you've prepared questions, and that you know what's going on and that you know what topics you need to focus on. And don't be a doormat. Get what you are entitled to get in terms of the things that we covered that you are entitled to in a debrief. But the more combative you are, the more closed-lipped the government is going to be, and this is a fact-finding mission. The more facts you have, the more fodder you have for a potential protest. So you always want to kind of walk that line where you don't want them to clam up, you don't want to have a cooling effect or a chilling effect. In terms of who should attend, lawyers differ on this. I have colleagues and I have peers and I have competitors out there, and some of us share the same opinions and some of us have different opinions. I generally say that if you feel sophisticated enough, and if you're a sophisticated contractor that can work with an attorney ahead of time to prepare questions, and that you can take good notes and know how to answer, any follow-up questions, you will probably get more information if you do not have a lawyer attend. However, if you feel like you're going to, not be able to think on your feet, or you're going to need a lawyer to jump in and ask follow-up questions, or if you're dealing with an agency that historically has been very difficult and very obfuscating, then absolutely have a lawyer attend. It's really, something you want to talk through with your attorney, whether it's a good idea to have a lawyer on the line or not. And obviously these considerations only come up if it's in person or telephonic. If it's written, they're just going to dump the documents on you. One thing, though, if you are going to have an attorney attend, always provide notice in advance that you're going to have counsel on the line. Agencies do not like being surprised by that, and they might even reschedule your debriefing because they don't have counsel on the line. So you always want to give them notice up front, just as a practical matter. Next slide, please. So I touched on this briefly before in terms of the distinction between DoD and civilian agencies. But in 2008, there was a deviation to the DFAR, which has now been codified or in the process of being codified in the DFAR itself, in terms of enhanced debriefing tactics on DoD post-award debriefings. And what it says is if you get a debriefing, and it can be telephonically or it can be in writing, but if you get a debriefing for any defense agency, you have 2 days to submit questions, and then the agency answers those questions, and your debriefing is not considered concluded until you get those answers. Excuse me. So in other words, if you are one of the people that falls in the exception of required and timely requested debriefings, you've already gotten, 10 days, not from the date of the notice of award, but 10 days from the debriefing. And now, if you're a DoD situation, post-award debriefing, you've now bought yourself some additional time, because after you get your debriefing, whether written or you hang up the phone from a telephonic debriefing, you have additional time to complete more questions, submit them to the agency, and then your debrief is considered concluded, and the clock to protest starts ticking once you get your answers back. Now, if you don't ask any questions, then there's no additional time given. And, that's why it pays to be a little strategic and talk about it with your lawyer in advance. Which questions do you want to ask on the phone? Which questions do you want to save for afterwards? There's some, strategy going on there, and you want to talk about that with your lawyer. But know that, you're in the best shape possible in terms of having the most amount of time to file your protest if it's a FAR Part 15 procurement for a defense agency, because you're going to get the required debriefing, and then you're going to get additional time to ask questions. And depending on how long the government takes to get back to you, then, you might have a significant amount of additional time to start preparing your protest. The tricky thing comes when you're talking about non-DoD procurements, when you're dealing with civilian agencies. Because again, especially if you're dealing with a civilian agency where they give you a written debrief, where do you get that opportunity to ask questions? That's where it becomes really important to jump on it and, ask for a debrief, and ask for a debrief along with questions you've already prepared, so that you get your chance to ask those, those questions and get your reasonable responses. If that's not a possibility, you can always ask questions after you get your written debrief, and you can try to ask them for confirmation that they'll hold the deadline. That's not always effective, though. So prepare ahead. Again, the takeaway here is talk to a lawyer who knows their stuff. Talk to them early in the process so that they can help guide you through not just the protest process, but the debrief process itself, because there is a lot of, moving pieces here. Next slide, please. So kind of focusing on that advice, best practices and strategy, engage an attorney early. And I mean early, as soon as you think there's something going wrong, as soon as you know you didn't get the award. I have people who have come to me after they've gotten their debrief and then waited 4 days. And it's like, well, great, now we have 3 hours to potentially prepare a protest for you. You don't want to be in that scenario. Obviously, the more time you have to be strategic, the more time you have to plan your questions, the better questions you can ask. And also, given the fact that there are so many moving pieces, and you have to figure out if you're even entitled to a debrief, and if what you got really was a debrief, and if you are allowed to ask additional questions, and what impact that may or may not have on your deadline. Lots of complicated questions there, and you want someone, with the know-how walking you through at an early stage, so that you don't miss a deadline, so that you don't miss an opportunity to use the debrief as an information gathering tool. And so that your attorney can help you kind of zoom in on the specific questions that you're going to want to ask that are most likely to be protestable. Other thing is fully utilize that opportunity to ask questions. You want as much information as you can gather. One, because it might be that, the more information you have, the more evidence there is that the government did something incorrect, and you can, divert the award back to you, hopefully. That's the goal, right? But also, it cuts both ways. If you're going to have an unsuccessful protest because there's a little gem for the government hidden in there, you'd rather know it before you spend money paying someone like me or one of my colleagues or peers out there, thousands of dollars to file a bid protest, only to find out, 2 weeks from now that, oh, yeah, if we had known that, we would have known that it was a lost cause. We wouldn't have tried. So you want to be, diplomatic in the questions you answer, both in terms of the tone you take with the government, but also for your own sake. Ask things about information that might be not helpful to you as well, so that you can suss out for, in a realistic and honest way, how good your chances are of prevailing if you actually tried to file a protest. You want to get all that information up front. It really pays to put as much as possible in the original protest. Also, the more arguments you make, the more documents you're going to get as part of the agency record. You want to really maximize the scope of information and set yourself up to get more information later in the protest process as well. And again, finally, with that DOD deviation, really want to talk to an attorney and maximize your time. That additional time you get to ask questions is really a good friend to you. Next slide, please. This is our last slide before we go to take some questions, and I turn it back over to Judy. But I want to leave you on the note that kind of harkens back to what I was saying a second ago, which is flesh out the good facts for you. Flesh out where you think the agency was weak, but flesh out where you think you want to make sure the agency wasn't or was strong as well. Not all protests are created equal. There's no benefit to you in filing a losing protest other than, money spent on legal fees and wasted time and effort. And in addition, you don't want a situation where even if you could win the protest, what does a win really look like is a question I ask my clients all the time. And by that, I mean, all right, we might be able to win this protest and it's going to go back to the drawing board and the agency is going to reconsider. Is it going to result in an award to you? Or is it going to result in them better documenting an award to the awardee again and just making it protest proof? Because sometimes you don't know. Sometimes it's worth a shot. But sometimes it's pretty clear that, all right, they made an error in their documentation and they're just going to go back and make the same decision again, and it's going to be perfectly justified, and you will have wasted your time and your money. So really important to use the debrief, both to find nuggets that are great for you, that are protestable, but also to get a full picture of what's going on so that you're not fighting a losing battle. Some of the things you want to look for in terms of fighting a losing battle are things like standing. And by that, I mean, where were you in the rankings? How close were you to getting an award? So you want to ask questions aimed at that, because if there was 30 people going after this and you were ranked dead last, unlikely that you're going to be able to file a protest. You might be dismissed for lack of standing. Competitive prejudice is the idea that even if you can prove definitively that the government made a mistake, if they correct that mistake, would there be a different outcome? In other words, yes, the government absolutely messed up on past performance. You should have been rated outstanding or, substantial confidence as opposed to limited confidence. But you were still rated lower than the awardee on the other three factors and you still had a higher price. So even if the error that you're absolutely right about, the government made an error, they should fix the past performance ratings. But if they did, would it make a difference, or would the awardee still get the award? That's a competitive prejudice issue, and it's really worth, fleshing out. If you check out our blog, govconexaminer.com, I just wrote an article or a blog post on this recently based on a recent case. This is an issue that comes up constantly. You also want to flesh out, objective versus subjective arguments. Arguments like, I should have been rated better because I know that I'm better than that are a lot less likely to succeed than, apples to apples type comparisons where you can show disparate treatment between you and the eventual awardees. So you're going to want to try to ask questions where you can get to some objective baseline. And as a practical matter, clients ask all the time, am I going to get blacklisted if I ask for a debrief, or am I going to get blacklisted if I go ahead and protest? As long as you are not being overly litigious and you aren't protesting when you know you have no justified basis just to be a harassment and a nuisance, no, you're not going to get blacklisted. This is meant to be a self-policing system. It's meant to, the system is meant to and is expecting bid protests. But that's one of the reasons that you want to use your debrief to really information gather and make sure that you're only bringing a protest when there is a justifiable reason, not just to be a nuisance or to harass people into giving you awards, not just to, drive the costs to your competitor up. That is when the agencies are going to start looking at you differently. But if you use your debriefs appropriately, if you come there prepared and with the appropriate tone, and if you only pursue legitimate, objectionable, issues in protests, you're going to be just fine. So with that, I'll turn it back over to Judy so that we can take some questions and, wrap this up. Thank you so much for joining us, and feel free to hit me with your questions.
We have some great questions. Go ahead.
I was going to say, if there's anything that we don't get to today, you've got my contact information up on the screen, and you can feel free to reach out to me directly or reach out to Judy, and she'll get you in touch with me either way. So with that, let's take some of the questions.
Let's do that. We have some great questions here, Maria, and thank you so much. This has been great. One of the questions has to do with the level of detail, and you did cover this to a certain extent. And somebody's interested in finding out things like winning hourly rates, proposed people who are proposed, key staff proposals, their resumes, direct comparisons of proposals and how they scored. Did I hear you right that that's a kind of information that you can't expect to get from a debriefing? Is that right?
That's correct. You're going to get certain information about the overall technical ratings and overall price. And you're going to get information about your past performance rating. And you might even get their overall rating, but you're not going to get down in the weeds. You're not going to get a copy of their proposal. If you ultimately go to the protest stage, the protest itself is going to be, the protest case, the docket where you file all of the documents is going to be protected, which means that you actually have to file an application to have access to those documents. Your lawyer, someone like me, can look at those documents, but the contractors and in-house counsel cannot. So the idea is, again, this is a process where, they want to have a self-policing system, but they've got to kind of balance that against the countervailing concern of, but I don't want somebody being able to get all of my pricing information and all of my personnel information and, therefore basically undercut my, being undercut by your competitors. So there are limitations on what you can and can't get. Again, if you go all the way to the protest stage, there's going to be an agency record where your lawyer is able to see everything that was submitted in your proposal, in the winning proposal, and they're going to be able to then use that to make arguments, but you as the contractor are not going to get that information. And I, as a lawyer, and my peers out there, we have to be careful about the level of information we share. But we can nonetheless, use our skills and our legal knowledge to apply and say, look, I can't tell you exactly what the issue is, but I can tell you that there are issues with what they put in their key personnel, and that's what I'm going to try to make these arguments about.
Well, related to that, how likely is it that somebody who files a Freedom of Information Act request to go see stuff is likely to get something back that's all redacted and has lines through all that stuff you want to see anyway? Is that probably what's going to happen? Months of time, dozens or hundreds of dollars, and then you get black things all over the document.
Yeah, FOIA requests, all that proprietary and confidential information is going to be redacted. There's no reason that you need that as a competitor. And frankly, if you're doing that separate and apart from the debrief and the protest process, that's one thing. And again, it's not probably going to be fruitful, but you're definitely not going to get it back in time to have any, benefit within the short protest deadlines. Right.
Two other great questions we have. First, based on what you see both anecdotally in your own practice and or data that you've seen, how often does the company that protested and wins the protest then actually go on to win the work in the recompetition? How often does that happen, roughly speaking?
So I would say in my practice, pretty often, because I counsel my clients in the beginning, as I said, what does a win really get you?
So your clients get good advice on whether or not there's some there. Broadly speaking, what are you seeing in people who are not your clients?
I would say across the board, maybe 60, 70%. I think there's plenty of times where going back to the drawing board results in, maybe a third party gets it. Maybe it's not the protester and it's not the awardee. Or maybe it's, back to the awardee and it's better documented, or maybe it's back to the awardee for a different reason. It really depends. And look, sometimes I tell my clients when it's clear, it's not going to go to you, but sometimes you don't know. Sometimes it's close enough and you're like, look, this could go either way. There's 3 different things that they need to reevaluate, and they messed up so badly that I can't tell if it's going to make a huge difference in the ratings when they reevaluate or not. So sometimes you don't know, and then it's just a question of talking it through and saying, is it worth the shot? How much money and how important was this contract to our company? Should we focus on the past, or should we just move forward? But yeah, it's not at all in a general sense uncommon, because the GAO and the Court of Federal Claims, which is where you go, or you can go to the agency level too, but generally you're talking about GAO or Court of Federal Claims and GAO to a larger extent. They're not going to go back and tell the agency you have to give the award to X instead of Y. They're going to go back and say, X is right, you did this wrong, figure it out and give the award out again. And it might go to, the same person again, or it might go to a third party, especially depending on how messed up the original procurement was.
Okay. Well, different question. Broadly speaking, and I know this can vary by venue, how often are contractor protests actually successful? How often is the protest upheld?
So if you look at the statistics on the GAO website, that they're not that encouraging. That being said, that doesn't take into account all the times that the agency voluntarily takes corrective action. Oh. And what I mean by that is you don't always have to go all the way through the litigation process when you're talking about bid protests. Sometimes the agency, once you file a protest, goes, ooh, yeah, I don't know if we did that the right way. And they might say, you know what, we're willing, rather than, litigate this for 3 months and have the GAO smack our hands and go back and say, bad agency, try that again. Maybe we're just going to try it again on our own. So there's plenty of times where at the early stages you file a protest and the agency goes, we're going to actually try to fix this, so let's just dismiss the protest. Those are all dismissals that don't get included in the win rate, but that's actually more of a win for a contractor because they don't have to spend as much money litigating it, and they got some sort of resolution. And then the question just becomes, what we just addressed, which is, okay, and then now that you've got some resolution in terms of reconsideration, is that reconsideration going to come out in your favor or not?
Okay.
But I would say probably win rate is like 55, 60%. It changes every year, but it's, it doesn't take into account a lot of the corrective action.
Okay. One of your agenda items was, how do you know, what are, if you like, the flags or signs that it would be worth engaging an attorney just to even assess whether or not to protest and or to go to the distance? What are the typical, if you had, let's say, 5 indicators that you really should be talking to, you should seriously consider engaging an attorney, what would those signs be?
Honestly, I think as soon as you get the notice that you were either excluded from the competitive range or the notice that you didn't win, if anything at all seems fishy. If the ratings that you got seem much lower than you were expecting, and, it's not just I have a higher opinion of myself than the agency did, but something objectively seems wrong. How could we have gotten a neutral past performance rating when we've got 7 years of past performance experience? Or, maybe it's the other way. Hey, I just Googled the company that won and they were just formed 3 months ago. How could they have gotten anything but a neutral past performance rating because they have no past performance experience? It's really, looking at the information and just saying, look, something doesn't seem right about this. And I think if you have any inkling, it makes sense to talk to a lawyer about, okay, what are my next steps from here? And you can take it in stages. Talk to a lawyer about, what do I do now? Is this a required debriefing situation or not? Then if it is, talk to them about what that means about putting questions together. Then have them, sit with you in the debriefing or not, depending on, the factors that we went through before. And then talk to them again about whether it makes sense to actually engage them to go whole hog and file a protest. The original stuff can just telling you, hey, let me take a look at the solicitation and see if this is a required debriefing. Hey, let me take a look at the 5 slides you got as your debriefing and see if anything looks fishy. That's not going to be that much of an investment. I mean, I guess that's all relative, but that's going to be, 10 hours worth of work. The protest is going to be more than that. But, I think it always, if you think something is wrong and you think it's worth it, explore it in stages and talk to a lawyer about exploring it in stages. And frankly, I've got a lot of people that call me in early September and say, hey, let's talk about how you represent clients with regard to protests so that if I want one later this month, we've already gotten all the preliminaries out of the way and we don't have to waste time when we're possibly operating on a 5-day deadline. Doesn't mean they necessarily engage me that early. Many do, but many just want to talk and have the preliminaries and get a feel for who I am. And I think a lot of my competitors and peers out there do the same thing. This is a pretty
it's so
collegial
important
area
to have
bar.
have an experienced a lawyer who's experienced in federal acquisition, really as part of your team, as part of your toolkit, so you're not then in trouble up to your eyeballs and then hunting around to find somebody to take your calls. And so that's your relationship with an experienced procurement lawyer is really valuable. That takes us to one of our other questions, and I know this is tricky, and I love the phrase, your mileage may vary. I love the fact that you were talking about dealing with things in stages. Can you give me a broad sense of ballpark of what the investment would be for, like, a consultation on the first stage? Is it worth it? Assessment? And nobody here is insert name of big giant prime. So we're not talking about multi-million dollars, but what kind of investment range might somebody be looking at for different stages of pursuing debriefings, first of all?
Yeah, unfortunately, that's a pretty hard question to answer, but I'll do my best. I mean, in terms of, hey, I just got a notice of unsuccessful offeror. If you have one issue, if you think that past performance seems messed up and you were tied, you guys had, maybe you were the lower price and you were tied on every other factor, and past performance is the only thing that could have made the difference, and you just need to have somebody look at that limited section of the solicitation and what you got in your debrief, or what the unsuccessful offer or notice said that you think is fishy, then that's going to be 2 hours of an attorney's time, and then obviously there's quite a range of hourly fees out there. If you're talking about hey, here's a very extensive solicitation and I need you to look at the IDIQ as well, and there are problems with every single one of the factors, and we already got a debrief and it's 50 pages long, it's really fact specific. I will tell you that I've done protests where, we had a very simple issue and we went to the agency and the protest letter was less than $5,000. I will tell you that I've done protests where, getting to just the protest stage was $70,000 because the protest was 70 pages long at the Court of Federal Claims and there were 10 parties involved. So,
okay.
That being said, lawyers, once they look at the documents and talk to you for, a half hour, should be able to give you an estimate as to what the next stage would be. As long as you can keep an open and honest communication, and we're not just, you're not letting the lawyer run with the ball and come back to you 3 weeks later with a $70,000 bill. What I try to do is, hey, let me take a look at this for a half hour. Okay, these are the things I would need to look at. That's going to take me 10 hours. Okay, now these are the things that we would need to do, and that's going to be X amount of money and X amount of hours. And, that versus what your chance of success is, do you want to go ahead or not? I think it's just taking it in stages and, at each stage assessing what do you know about the likelihood of success versus what do you know about the costs that you'll need to sink in to get to the next stage.
I love that. So another reason why not just whoever your lawyer is around the block, but working with somebody who is experienced in federal acquisition can quickly assess this is going to be a 10-hour project. This thing is a Hail Mary pass. So that's super. Maria, we've got some resources that we want to share with folks. And I know you've got a little bit of linger time. So let me get to some resources here and then we'll come back. So thank you for excellent questions. There are a few more and we'll want to cover those. And so I want to ask you, please drop in the chat, what one thing do you commit to trying today? Or what's your aha or your big takeaway? What did you learn that was helpful? Drop in the chat and let us know what you're going to do or what you think has been most useful. In the meantime, we covered a lot. When and why to request a debriefing, when a debriefing is and isn't required and why that matters. Debriefing versus brief explanation and why that matters. What you do and don't get in pre and post award debriefings, who should attend, how to prepare, when to engage an attorney, and how debriefings can impact bid protest filing deadlines. So again, thank you so much for those of you who have responded to the poll. If you haven't, please help us help you. Let us know a little bit more about you and what's important to you. And we have resources for you. I love giving things away. So this is one of my favorite parts of the webinar. We're going to send you links to all of these things in the follow-up email, and they're in the chat right now. So you can go get these things. One of the things that we want you to be able to do is to find the right buyers, get in front of them and stay in front of them to win them over. And so the 5 people you need to meet, players at all the layers, is really important. The first experience I had with debriefings, Maria, was when I was just my first year in the federal arena, and a Canadian furniture manufacturer, Krug, in Kitchener, Ontario, they had lost their GSA schedule bid at a time when the GSA schedules were competed not all year round, but on a regular schedule. If you didn't win your competition when the competition window was open, then you were going to wait 5 more years. And there were 11 different deficiencies, and they came in and they asked to go set up a debriefing. And so I went along with them. I was their trade commissioner, their kind of government representative, and the 2 guys from the company. Well, there was the contracting officer, 2 contracting specialists, the Art Hackney, the head of the furniture center, 2 lawyers, an intern, and 5 people who had never seen a foreigner before. We're all jammed shoulder to shoulder in this little conference room. And they went through and they knocked down 10 out of the 11 bid deficiencies. We actually dispensed with those. Then they got to the one last thing. They were asked for underwriter laboratory data, and they actually just provided Canadian Standards Association data on fireproof. They didn't answer the question. They were out. But the friends they made meant that they were able to continue to develop relationships and went on to win over $11 million in business. So it's good for debriefing is good for relationship building, but it's important to know who your players are at all the layers. So that's why this is a really valuable handout. Here's another one. We're doing this briefing at the time where we're ready to start a new federal fiscal year, wrapping up the end of this fiscal year. Getting debriefings and post-award conversations when you need them is one of those steps, but there are 7 other steps that can help you get your new fiscal year launched. This is a free infographic to help you do that. Our company's flagship program is the Federal Business Intensive, suitable for small teams so that in 8 weeks or less, you create a solid relationship pipeline into at least 3 places where you are confident you can win work, and you're on your way to winning over 10 times back your investment well within 12 months. Find out more about that at the link that's here and explore whether or not this might be a good plan for you and your company to work with us and ours in 2022. We've got other links and resources for you. Check it out and sign up. Find out more about our blogs and upcoming free events. And let us know what we should be talking to in the year ahead. Here's the link to book a chat with a Federal Business Breakthrough. And so we've got time for maybe about 5 or 10 more minutes of questions, and you've got them lined up for us. So let's go on to some of these. Catherine wants to know this. Some IDIQ contracts have awardees with prices that are almost between $10 and $50 million apart. How does the government justify price reasonableness in a case like this? For example, the Army ADMC-3 contract.
So I'm not familiar with that particular contract, but generally it's going to depend on what the solicitation said. If they've got things that are considered far more important than price is going to be a factor. But if the way that the solicitation has been structured, they say, that the non-price evaluation factors are far more important than price, or significantly more important than price, or, factors 1 and 2 when combined are more important than price. There's a million ways that they can word it. But it doesn't have to be the lowest price. Obviously, lowest price is considered better, but the whole terminology of trade-off and best value means best value taking into account the other benefits that the other non-price evaluation factors convey. So it's not necessarily going to be the cheapest. Now, obviously, if you get into a situation where someone is more than triple the price, as opposed to there being a difference of 10% or something, that's going to get a little bit harder, I would think, for the government to justify. But it depends on the importance of price and how much the awardees outweighed everyone else on the non-price evaluation factors.
Got it. And with an IDIQ, and it was an interesting thing, if you're awarding the IDIQ, that's like the fishing license for a limited pool. The offerings, what somebody has to offer on their on the IDIQ may vary wildly, is another piece. We've got another question. In layman's terms, what are some indicators to figure out whether or not to involve legal? We receive award notices all the time, but assume it's the incumbent or relationship. So what kinds of things should we look for about, I guess, to determine things that are fishy? I think you kind of answered that. Our questioner doesn't want to create a protest for the sake of it, but she's asking, should we attend a debriefing just to learn? From my very first years in the federal arena, Yes, I was looking at my research on this and I was finding a briefing I did before. There are maybe 5 considerations for reasons to consider a debriefing. One is lessons learned. Get a debriefing even if you win. Because as you said, Maria, nobody has a perfect proposal. It shows humility and a sense of wanting to do your very best. And you also want to get the sense of whether you won by a landslide and everybody's just bouncing off their seats with joy that you won, or you have this dead feeling in the room and you get this sense that nobody's really happy that you won. And you want to really know what's the tone of the room, but what are all the things you can do to be successful?
Exactly.
You can certainly gain marketing information and learn who are the players at all the layers. Sometimes you'll get one person answering monotone questions on the phone. Other times you may see a whole cast of characters who might be interested in meeting you. Maybe it was your first appearance in an agency. They were really curious about you. They want to meet you too. They're people. They're people. Sometimes you're doing fact finding. Certainly sometimes your reason is to gather facts because you know something was absolutely not right and you're going to have a very comprehensive shopping list of facts that you are gathering. And sometimes there's the idea of helping the agency defend the award as well. They are bringing their people into kind of almost do a pre-rehearsal and get all their facts together and make sure they haven't missed a trick. So that happens too. Other answers. Let's see. Other questions. Deanna wants to know, is it a red flag when a lawyer asks a small business what the protest rules are? Deanna, tell me a little bit more about that. If you can drop it in the chat. Hang on for a second. Deanna, can you come live? Deanna? Deanna, can we hear you? All right. Not sure, Deanna. Can't hear you. Can you unmute?
So I can weigh in on this, I guess, just
Okay.
preliminarily.
Sure.
I think there's 2 different questions there. You specified that this was a small business. You know, we were talking about debriefings as a tool to a bid protest. There are also out there small business size and status protests, and they are governed by a different set of rules, and debriefings don't really come into play, although you know, if you're thinking about small business size or status protests, if you can time it that you get a debriefing and can flesh out those concerns as well, so be it. But generally speaking, you're going to have to go with a size or status protest just based on what you know. But yeah, there are FAR provisions that apply. You need to be familiar with how these solicitations work. You need to understand how the forum rules, by that I mean the GAO or the Court of Federal Claims work. And if you're also bringing small business stuff into it, you need to be aware of the small business regulations. And if you're bringing a size or status protest, you need to be aware of the SBA and how they handle small business size and status protests. This is a niche area of law, you know, and even those of us who are government contracting, not all of us specialize in the same things. You know, I don't do a ton of mergers and acquisitions. Some other people do bid protests, but not claims work. Some people do claims work, but not False Claims Act, you know, compliance work. So it's really important to get an attorney that's familiar with, you know, federal contracting, but specifically with bid protests and, you know, to the extent applicable, small business rules. And I'm not saying that someone who doesn't know that is a bad lawyer. It's, you know, if you asked me about employment law, it wouldn't be my strong suit, and I'd have questions. But I think it is a sign that perhaps, you know, whoever you're talking to is not facile with the things they need to be facile with in order to quickly move you through this process. It doesn't mean they couldn't do it, but it means that there might be some hiccups. And given the short timelines and the serious consequences for missing a timeline, when you're dealing with this type of, you know, legal situation, I would be a little bit worried about relying on someone who needed time to get up to speed, at least, you know, their first go round.
And I love this question that we got. Let's see here. Another from Diana. What kinds of smart things can a government contractor do to prepare to get smart while they're working with their lawyers in order to, if you like, lower the costs a little bit? What are the things that smart clients do to get the most value out of their time with their lawyer and not necessarily have the clock running out of control? A smart client is probably a lot more fun to work with than one that is just totally clueless, right?
Yeah, I mean, I think it's a question of, you know, come prepared. I have a client that reached out last night and we're going to be talking later today. And they came prepared. They were like, here's the notice of unsuccessful offer we got. They had already gone ahead and gotten their debrief, but I've worked with them enough that they know how to do that. They got their debrief. They sent me the debrief, and they said, they attached that, and they attached the sections of the solicitation that dealt with past performance and with the technical requirements. And they put in the email, these are the specific reasons that we think we potentially, have a leg to stand on in terms of arguing about the technical requirements. So I think, educate yourself as to what your solicitation says. Read some protest decisions. You can go on the GAO docket and read protest decisions. You can, if you Google, there's a lot of people out there that share blogs, including me, about, GAO protest decisions. Start kind of educating yourself about what a successful protest looks like and know how to hone in on what look like potential issues. It's all going to come down to what the solicitation framework said the government was going to do and comparing that to what they did do and narrowing down where there's a deviation, and that's your protest basis.
Got it. Last question. Can the government proceed with a contract award and operate in the face of a contrary GAO opinion?
So while the protest is being litigated at the GAO, unless you've filed early enough to get the automatic stay, everything is on pause until the GAO says, yes, the agency did okay here, or no, you've got to go back to the drawing board and decide. There is an exception if the agency is like, hey, this is an emergency procurement. For example, some of the Hurricane Katrina stuff, some of the recent storm stuff, they might say, automatic stay aside. No, I'm sorry, we have to go ahead and start the work here while this is being protested. Once the GAO says go back to the drawing board, let's say that if the GAO says going back to the drawing board, then the agency no longer has an award decision. They have to go back and reconsider consistent with what the GAO said. If the agency says, yep, you're good, go ahead, yes, the protester has the ability to file, for a reconsideration, but in the meantime, in most cases, the procurement is going to start at that point. So it's one of those things where generally it depends on if you filed in time to get the stay. Once the GAO makes their call, though, if they said, if they agree with the protester and say, no, the protester was right, then the government's supposed to go back and make a new award decision. The only way that it would keep going forward is if there was some sort of emergency, or if it's not necessarily the new contract that's going forward, that they just extended the incumbent's performance on their current contract, which happens a lot if there's a long protest time.
Mm-hmm. And with that, Maria, thank you so much. And thank all of you. I wish all of you a fabulous federal fiscal year end, and go forth and win. Take advantage of the resources that we're sending you, share with friends, and let's talk if you're looking to launch your new federal fiscal year and find your way ahead. Maria, this is our third webinar together. I hope everyone listening finds the other two that you've already done on teaming and subcontracting with us. And we look forward to working with you again. Thank you so much. And everybody, let's talk soon. Let's close out the fiscal year with lots of success.
Thanks, Judy. Bye-bye.
Bye-bye.